Realtors. I'm Scott Peterson. Thank you for joining me for another edition of Legal Bites. This is the second Legal Bites in a series that I'm doing here, a series reflecting some of the changes and some of the changes that have caused more hotline calls, more questions from realtors around the state as I've been teaching classes and so forth, related to the 2022 changes to the contract to buy and sell. As you guys know, you've been working in that contract now for more than a month and a half, going into 2 months now, and you've seen there's a lot of changes, a lot of substantive changes, a lot of clarification changes, structural changes. One of those changes, I would say structural and clarification, has been to the water aspect of the contract. Water everywhere, but not a drop to drink. That's somebody who's stranded on a raft somewhere, which is not anything to make light of, and I certainly don't intend to, but it does create a nice title for what some people might perceive as kind of a boring topic, but please don't think it's boring. This is exciting stuff, right? Water rights. I understand a lot of brokers around the state don't deal a lot with water rights specifically, more deal with well rights as they relate to property, and frankly, I think the vast majority, particularly in larger metropolitan areas, don't deal much with water. It's a water district, and they don't have to think about a lot of this stuff. But I've had a few inquiries about how some things change now that we created a rights examination deadline for water, and as that relates to the property condition or property inspection deadline. And I want to just clarify, it's a very good question and very sort of insightful. It made me really think a little bit about the way to address this, at least what my thoughts were, and so I wanted to share those with you guys. So as you know, in paragraph 2.7 now in the brand new contract, we get into the water rights, well rights, and it's not a distinction, it addresses both of them similarly within paragraph 2.7. All right, and then it creates in 2.76 contingency. You can check a box to say yes, that contingency or date or deadline will apply, or no, it will not apply, subject to whatever has been disclosed above. The reality of it is you get a lot more complicated and need a lot more, I believe, rights examination and get attorneys involved in situations where you're dealing with more conventional water rights, and that would be deeded water rights that are being separately conveyed, access rights to open water, potentially water stock certificates, whatever the right may be. That's more complicated, and for those kinds of things, I would encourage brokers to take advantage of, or buyers to take advantage in the offer of checking that box, saying we're going to take advantage of that water rights examination deadline in the contingencies, because they're probably going to need more time. You certainly shouldn't be reviewing those as a broker, and your buyer's probably going to want to take those to a qualified water attorney, make sure that they understand what those rights are, that they're compliant with whatever the buyer's intentions or needs are, that they're good, that there's not issues or encumbrances or anything else that might impact the quality of those deeded or other water rights. And so in the case, again, where you're actually conveying, or the seller's actually conveying to the buyer deeded water rights or something more complicated than well rights, I would encourage you to take advantage of that deadline. But also embedded in that general theory of water rights are the well rights. Well rights are generally less complicated. Now, I don't want to make too many assumptions, and everything, there's no perfect assumption when you do a real estate transaction, but I think as a general matter, wells are located on a property, there's a well permit, the well documentation in and of itself spells out to a buyer pretty specifically what the rights are with regard to access and use of that well. All right, so I don't know in a situation where there is a well being transferred with the property and disclosed in paragraph 2, if your buyer is going to need to be taking advantage of the new examination contingency that's created in, or water rights review contingency that's created in paragraph 2.7.6. It could be pretty clear that on its face what those rights are in the case, again, of a well permit, okay? So I'll leave that to the transaction and the specifics of your specific transaction, but be aware that there's a difference between rights and condition of the well. All right? And I think it's important, regardless, to understand that a well right might be the buyer has, or the well owner has the ability to pull X number of gallons and only X number of gallons or acres or however water is measured in that specific case from a well in any given day or week or month or year or whatever it might be. That would be a right, right? That would be their ability to use that water. Another right might be an ability to use the water for agricultural purposes versus, household purposes. Those limitations are probably going to be reflected directly on the well permit, and it's going to be very, very clear. It's not like a deeded right that needs to have maybe a title examination and much more complicated, probably, legal review, again, in most cases. But delineate the well rights from the condition of the well. If you were to say then the well is not potable water, or it's not enough water for my use as a buyer or my intended use as a buyer, I believe that those are property conditions, not well rights, but property conditions. In other words, I can't use the water, the well is not going to distribute enough water for whatever my intended use is. Forget about the right, that's a condition issue. Or the water that's being pushed out of the well is not potable and I need it for potable uses, right? It's only good for, watering the lawn or non-potable kind of uses. Those are condition issues. So make sure that you're understanding the delineation if you are using those two deadlines, examination of water rights as it relates to the well versus the condition of the water that may be coming out or the volume of water that may be coming out, which is going to be a property inspection objection. And so that deadline is going to apply. So hopefully that makes sense. Again, I've had some questions about how that new examination deadline dovetails with the inspection or property condition or property inspection deadline. And if it's a condition of the well, volume of the well, use of the well, that's going to be your property condition deadline. If it's going to be a rights related to the well, how much water you can take out, how you can use that water, that's going to be the earlier deadline, the water rights examination deadline. So understand that distinction. I know this doesn't impact a ton of you guys that are doing metro area, no matter where you are, kind of deals, because well and water rights don't generally apply. But for those of you that are, and specifically if you're doing the well stuff, understand that delineation between how those two deadlines might interact with each other. If you have more questions about water rights, don't ask too hard of questions about water rights. If you can't tell, I'm not a water rights lawyer. I've never had any expertise in that. But if you're curious about how water rights and well rights and they intersect with the contract, call the hotline. It's a great resource, 9 to 12 and 1 to 4, Monday through Friday. And that's a great way to get some answers to specific questions that you may be having in your deal as it relates to paragraph 2 or any other paragraph in the contract. Thanks so much, guys. We'll see you on the next episode of Legal Bites, and we're going to do more contract series episodes. So stay tuned for those. Take care.